just an outline.
He wants to get over wire.
Hi, I know you.
I came to take notes. Do I have to take notes?
You know Susan? Of course. Sure.
How are you doing? Here's an outline of what I'm going to talk about.
Thank you. Did you do this or did Sherry do this?
I did. However, I ran it by Sherry and she said it was okay. Hey, Tim. Tim. Hi, honey.
Hi. How are you?
Good. Good. Been here all day. Oh, I'm now teaching. I have actually two students.
Sometimes it doesn't.
Amazing. I got two students. So, how are you, honey? Good.
Let me say hello to Elliot here.
So I got all my paperwork. Everything's done. Thank you. Right after I talked.
Hi, sweetie.
Came in. You must have done
Okay. Did I have a tendency of doing this? Okay. Bubby and Zadie. The Bubby and Zadie Trust. Okay, everyone. I know most of you. Some of you I don't, but my name is Elliot Luchs. I think you know that. I've been an attorney for 51 years. When I became an attorney, Judy Lear was only 11 years old. Judy and I have the same birthday. Anyway, and I've been a Temple member for 40 years, and back in the 90s was president for a while, and have some experience. And I've been the, I guess, unofficial or official attorney for the Temple for about 30 years. And I was asked by Sherry Cruz, who can't be here tonight because she's having, her son's having some surgery, to help with a program regarding estate planning and with some plan giving issues that we're going to talk about at the end. I passed out an outline that I'm going to be using, and I know many of you already have estate plans, and probably what I'm going to say you already know, or if you don't know, you'll get a refresher on it, or maybe it's something that you haven't thought about before. And what I want to do is discuss. I think I'm going to take this off. What I'm going to do is discuss various aspects of estate planning. Closer to your mouth. Various aspects of estate planning. I was talking to an associate attorney I work with, and I said, one thing about estate plan is, or probate or whatever, everybody is going to have one or need one or going to die. So not everybody gets a criminal attorney, not everybody gets a divorce attorney, not everybody gets a personal injury attorney, but everybody's going to die. Everybody has a family. So when you come to estate planning, it affects everybody. And we find in our practice, people sometimes are quite lazy. They don't do something, and then there's a death or an incompetency or an accident or a stroke, and then it just gets very difficult, expensive, time-consuming, and emotional. So we try to, in some of these estate plans, work out what would happen if. You know, I say doctors always try to rule out things. We're going to rule out this. I always say, what if? What if you fall down the steps and bump your head? What if your wife falls down the steps and bump your head? What if you both fall down? And everything is what if this? And there's things in a trust, and those of you who have trust know there's probably a lot of language in there. It's never going to apply to you. But if it does someday apply to you, you're going to be glad it's there. So some trusts I've seen could be 60, 80 pages long. I've seen some that could be 10 pages long. I had one come in, it was a Wolcott form. If you remember what Wolcott forms are, it was 3 pages. And it was 40 years old, and it was very difficult to read because they had recorded it, and we couldn't read it. And this client needed to open a bank account and couldn't open a bank account because nobody could read the trust, but it was 3 pages. Yes, it was very small, and it was recorded, like in 1988 or 1990, and trying to read it, you couldn't read it. So, but point is, it was a valid trust if you could have read it. It was 3 pages. And I know an attorney in town that specializes in estate planning, and his trust runs 60, 70, 80 pages. My trust usually runs probably 23 to 25 pages. Could be a little longer, but that's usually the standard, well, for me. And it covers pretty much everything we can, and it's just that some things, some trusts cover things that will never, never, ever relate to you. And when I do them, I try to keep it to what's possible that could happen. So I want to talk about a couple of different things. If you die without a will, it's called intestate succession. And if you die without a will and you die intestate, we say, then your assets go pursuant to a statutory scheme, such as if it's community property, then it goes to your spouse. If you don't have a spouse, or you have, let's say, separate property. We find nowadays second marriages where somebody will come into marriage with their own property, and then they get community property with their new spouse and they die. The separate property is distributed between the spouse and the deceased children, if he or she has any children. And there's a formula for that depending on how many children there are. If you die without children, then it goes up the family tree to your parents. If you don't have any living parents, it goes sideways to your siblings. And I had a situation once where somebody died. He was a single man, had no children, but he had 9 siblings. And many of them were dead, and the dead siblings' share would go to his or her children. And we had like 25 different heirs that we had to deal with. And it was a small estate, and it was just a real chore to get that done, trying to give notice to all 25 people. Now, if you have a will, then, and if you die intestate, you have to file for a probate. A probate is a court action. It's supervised by the court. Some of you have probably heard about probates. You have to publish in the newspaper, and then you have a hearing, and the disadvantages of a probate, I listed some on my sheet here. I think number 1 is it's not fun. Anybody that's been an executor of an estate or an administrator estate usually says, many times, you know, I did it, I don't want to do it again if I don't have to. Sometimes they go pretty smoothly, but it's a court procedure, it costs more. It takes, in Riverside, it depends. It could take a year, it could take more. I had one in Orange County a few years ago that went 2 years because I took 6 months to get a hearing date. In Riverside, you can usually get in 60 to 90 days. But it's a drawn-out process, and legal fees are set by law in a probate. And I can tell you exactly what they are. People say, what's it going to cost me? Well, what's the value of your estate? Let's say you had $1 million estate. $1 million estate probate fees are going to be $23,000. And it's 4% of the first 100,000, 3% of the next 100,000, 2% up to $1 million. Do the math, comes out to $23,000. Then what people do is say, oh my God, $23,000. And I say, wait, let's put this in perspective. If you sold $1 million house, your real estate broker is going to charge you $50,000, 5%. So my fee on $1 million probate is 2.3%. Every lawyer in the state's going to charge you 2.3%. Now, and there are some instances where we can ask for what we call extraordinary fees if there's something special going on. But normally, you're just going to pay the statutory fee. With a probate, you're going to have an executor or an administrator. And that person also is entitled to the same fee that the attorney is. In many instances, the executor, administrator, waives their fee because they're usually one of the heirs, but they're entitled to the same fee. The probate process is public. Anybody could go to the courthouse and look at your file and see what's in it. Like I said a moment ago, it could take a year in Riverside. And another thing's very important, Medi-Cal liens. Under the current law, Medi-Cal would be entitled to reimbursement from the probate estate. So if you have a probate and there's a Medi-Cal lien, that's going to have to be dealt with. If the property's in a trust, which I'm going to speak about in a minute, you don't have to worry about a Medi-Cal lien because the statute specifically says to be paid from the probate estate of the decedent. There is no estate and there's no probate if you're going through a trust. So that's an advantage of one of the advantages of having a trust. One other thing that's interesting is my daughter works in a bank, and somebody walks in with a will and says, "I'm the executor. Give me the money." No, it doesn't work that way. "Well, I'm the executor. Give me the money." No, you're nominated as the executor. The court appoints you. So in probate, somebody, let's say the named executor, will file a petition and say, "The will says that I am to be the executor. I'm asking the court to appoint me the executor." Nowadays, sometimes we just say personal representative, because that covers executor and administrator. Administrator if there's no will, executor if there's a will. So it isn't automatic. People just walk around with this will and say, "Look, I'm in charge. It says that I'm the executor." No, it doesn't work that way. You have to go to court. Now, let's move over to the trust, which is let's say the most common thing we're doing now. A trust is an agreement that creates there's three parties. There is in my memo here, I said trustor, settlor, creator, or trust maker. They all mean the same thing. Sometimes you'll see a trust. I use the word trustor because that's just the way I've always done it. Some people use settlor, some say creator, and some of the newer trusts, new languages, people just say the trust maker. So that would be the person making the trust. Then there's a third party, which is the trustee. Think of the trustee as being the manager, okay? And the trustee is in charge, and the trustee manages the estate. And then you have the beneficiary. The beneficiary during your lifetime is yourself, in most cases. And then upon your death, it would be to whomever you direct or state in your trust. Could be your children, could be anybody, okay? I've had people leave money to Humane Society. I had a client that left his entire estate to Guide Dogs of America. He had no family, and he went through the phone book one day and said, "That sounds good." And he left this, his estate is over $1 million, and this goes back about 15 years ago, to Guide Dogs of America. And I called these people up and said, "Hey, you're the beneficiary of this estate from a guy named Mr. Smith." They said, "We don't know Mr. Smith." I said, "Well, he left you $1 million." Yeah, and it took 10 years to administer that trust because of issues. What? Yes, that's right. Left money for cats and whatever. I've had people that will leave money to somebody. "I'm going to leave you $10,000. You take care of my pets." Okay, but you can do whatever things like that. What I do want to mention is that comes up in our practice is who's going to be the trustee? Who's going to be the manager? Somebody comes in, they have 4 children, they say, "I want all 4 of them to be co-trustees." And I say, "No, please don't do that. Somebody has to be in charge." "Well, yeah, but I don't want one kid to think," well, you're going to have to make that decision. But can you imagine having 4 bosses and all 4 of them have to agree? I always ask, how do your kids get along? "Oh, they get along great, except for the one that's in prison." And but sometimes I've had situations where there's a couple kids, they all get along, they get along great. There's no issues. Trust administration goes through in 6 months or less. But sometimes, we find nowadays, unfortunately, well, I've got 4 kids. One's a drug addict living on the street. The other one hasn't worked a day in their life and lives in our basement, plays video games. And there's one responsible one out of the 4. What are you going to do about that? And I don't want to leave all this money to some of these kids, because in 2 months they'll be gone. So we have to work on things like that. So we think you don't want to name that person a trustee. Who would you name? And so I've had some situations where I don't have anybody. "Well, how about your brother-in-law?" "No, I don't trust him. Or he's older than I am. I don't want to do him." And it used to be you would have trust companies. Remember, you'd have bank and trust. Don't have that anymore. You go to a bank, like let's say B of A or Wells or one of the large banks, U.S. Bank, unless you have a very large estate, they're not going to want to deal with this. There used to be a bank, if you remember, Pomona First Federal, which became PFF. They were out of Claremont, actually Pomona, but I think they had an office in Claremont. They had a local trust department, and all the attorneys in town would use PFF because they were local. And the lady that ran it lived in, matter of fact, used to live right up the street here. And then PFF went out of business and was taken over by US Bank during the crash of, 2008 or whatever. And US Bank took all these trust accounts, sent them to somebody in Vancouver, Washington, and nobody knew who the trustee is. You would call and you'd see somebody looking at a computer screen. And then what they did is they closed out the trust and they won't take any new trusts. I know B of A had a trust department in Rancho Mirage, but you had to have $10 million or something before they'd even talk to you about it. So it's really hard sometimes to get someone to be your trustee. I've talked to many people who have done this when doing it, being like an executive administrator or a trustee, and when it's done, a lot of times they say, no, I'm not going to do it again. Another thing, people come in and they say, I don't want to do it, but my uncle asked me to do it. I feel obligated. And I say, this is not indentured servitude. You don't have to do it if you don't want to. Yeah, but I kind of feel guilty that he asked me. Well, that's your choice, but you're not required to do it. And it could be a lot of work. It could be a lot of work. Now, it depends on the estate. I have one now where the guy died and he was a real estate investor and he had 10 rental properties. And the trustee is managing all 10 of these properties and doing the repairs and whatever and getting them ready for sale. And then we've got people that are saying, when do we get our money? You know, wait a minute, he just was buried yesterday. You know, when can I come and pick up my check? And a lot of work being done. So you have to understand consider who's going to be your trustee. Who do you trust to do this? Well, I can't trust my kids. Or what if you have small children? You can't have, a lot of times it'll be, when I did my trust, I named my parents. But that was 35 years ago. Then my parents got older, I had to name someone else, and then now my kids got older, they're the trustees. In fact, in my case, I have 2 children, some of you know. My daughter Molly's just going to be 40 in 2 weeks, and my son's 44, but he lives in Hawaii. So I'm naming Molly the trustee, and she works at a bank, and she understands trust better than my son does. So I told my son, don't feel bad that she's the trustee, and he said, that's okay, I don't want to do it. So it's really a big decision. When you're younger, you think about who's going to be the guardian of my children. I actually had a couple got divorced over that. They could not decide on who would be the guardian of their children. And that was one of the hardest decisions. Who's going to be the guardian? Well, who's going to be the trustee taking care of the money for your children? And that's a big, big decision. We have the beneficiary here. So that's obviously who's going to get the money or to get the property when you die. Quite often parents will say, okay, I got 2 kids, so just give it to them equally. Or I have grandchildren. I want to put some money aside for grandchildren. I want to send some money to a charity, or I want to give some money to somebody else, or whatever it is. But that's a decision too. Now, if you have a revocable trust, and most of these trusts are all living trusts or revocable trusts, they can be amended. I tell people they're having a tough time making a decision. I said, you can always amend it. Let's get it done, and you can change your mind tomorrow, but let's get it finished so you at least have something. When there is a death, then the trust could, if it's a joint trust, could become irrevocable, or in some instances we say it isn't irrevocable when the first spouse dies. Sometimes they are, sometimes they're not. We have a situation, let's say there's a blended family and husband has two children, wife has 2 children, and the trust says when they both die, it gets divided equally. Well, you don't want, when spouse number 1 dies, the surviving spouse to amend the trust to delete the stepchildren. So we, in those cases, say you can't amend the trust. But let's say it's mom and dad, they've been married 40 years, they got 2 kids, whatever. I sometimes say, do you have a problem letting your surviving spouse amend the trust if they want to? No, they're not going to disinherit our children. So it's easier. It makes sometimes things easier. Excuse me? When I do a draft, I will put in 2 paragraphs on my draft, and it'll say, one is can't be amended, and they'll say or, can be amended, and I ask the client, which one do you want? And what I do say in my trusts is even the ones that cannot be amended, that you cannot amend the distribution of any of the assets, but you can amend administrative provisions to make it easier to operate. But you can't change who gets what, and you can't change the duties of the trustee. But so I'm doing one right this minute where they had a trustee that does not want to be the trustee. So there was a couple, one of them died, and it said, you can't amend, but you can amend for administrative provisions. And the appointed trustee or the named trustee doesn't want to do it. So we have to do an amendment. The survivor is going to do an amendment naming his daughter as the successor trustee, not changing anything else, just making the trustee. Okay.
Excuse me, if we have questions, we have to ask them in the microphone so people on Zoom can hear. I'm going to leave the microphone right there.
Another thing that I mentioned about the advantages of a trust, it is private. Nobody sees it except the people involved. You don't have to post a bond. You don't have to publish in the newspaper. It avoids, I was talking about conservatorships in a second. It does not provide or require Medi-Cal reimbursement, like I said before. Let's talk about conservatorships. Very important when you have a trust. Most trusts, if not all trusts, will say in the event one of the parties, one of the trustees, let's say it's husband and wife, becomes incompetent, then the other trustee can act as a sole trustee. And then most trusts will have, what is the definition of incompetency? They always say if there is an order by a court, or we'll say, the ones I write, and most lawyers do the same thing, if two doctors examine that person and in writing certify or state that this person is not able to handle financial affairs or whatever it is, you get two statements from two different doctors, not related by blood or marriage, and then with that, that person then is, should I say, removed as the trustee, and the other spouse acts as a sole trustee. If you don't have a trust and one spouse becomes incompetent and can't sign things, you have to go to court and get a conservatorship. I don't know if any of you have been involved in a conservatorship, but they're very expensive, very time-consuming, and really aggravating. And the courts are very careful about appointing a conservator for somebody. They don't want to take somebody's rights away from them until the court is convinced that that person needs a conservatorship. But with a trust, you get around that by saying if two doctors say you're incompetent, then you're incompetent. And it happens quite often. Matter of fact, in many cases, both parents are incompetent, or we'll have one parent's deceased, a surviving parent. This happens every day. Someone says, my mom, my dad, they're in their 80s, whatever it is, and they can't pay their bills. I'm worried they're going to be taken advantage of by somebody. What do I do? And and if you could get, and I ask them, will they voluntarily resign as trustee? Well, I don't even think my mom understands what that means. So and then the next question is, have you had her examined by a doctor? Well, we have an appointment tomorrow. I said, okay, tell you what, call me after you talk to the doctor. But what you need to do is you need to get the doctor to examine your parent, and if they determine that that person is incompetent or not able to handle their affairs, they have to write a letter, and we need two doctors. So you got to get a second opinion. And that happens a lot. It happens on a regular basis. It really does. Let me tell you about some trust administration. So what?
Does California being a 50-50 state,
Community property.
community property, does this trust supersede that in any way, or how does that all work?
The character of the property is not changed by putting it in a trust. Now, I'll give you an example. Let's say you have separate property and then you have community property. And when we set up a trust, we transfer, I was going to get to this screen, but you transfer assets to the trust. Trusts will normally say the assets on Exhibit A attached are community property. Assets of Exhibit B are a separate property of husband. Exhibit C is separate property of wife. And then there's a provision that says, in the trust that I write and the ones I see, is that transferring this property to this trust does not change the character of the property, okay? I have, again, people come in our ages, right? And I ask, what did you have when you got married 40 years ago? I had an old Volkswagen and my clothes. So everything that you have today was acquired after marriage. Yes, it's all community property. Except if you got an inheritance. Get any inheritances? No. Did your wife get any inheritances? No. It's all community property. But we have somebody says, yes, I got a $100,000 inheritance from my parents. Well, that's your separate property. And one thing I do tell people, and they get mad at me, and I will say to them, okay, I'm just doing my job here, but if you got a $100,000 inheritance and you commingle it and your wife kicks you out next week, you might have a hard time getting that $100,000 back. So you might want to keep it separate. And I said, don't get mad at me, but I'm just telling you, it's like a doctor telling you don't smoke. You still want to smoke, that's up to you, okay? Let me talk about trust for a minute, going over here. I've got the Bubby and Zadie Trust, all right? And this is the Bubby and Zadie Trust. And Bubby and Zadie are the trustees of the Bubby and Zadie Trust. And what you're going to do is we create this trust here. And we're going to transfer your house to the trust, non-retirement bank accounts, life insurance, other investment accounts, personal property, and other things. Not retirement accounts. We'll talk about that in a minute. And we've got Bubby and Zadie, trustees of the Bubby and Zadie Trust. So Bubby and Zadie are the managers. Okay, what happens if a manager dies? We just appoint a new manager. Now, if this was not in trust and Bubby and Zadie died, who's going to sign documents to sell their house? Who's going to sign the documents to get the life insurance? Well, life insurance might go by beneficiary designation, but who's going to be the owner of the policies? And bank accounts, go into a bank and say, I want my parents' account. No way. They won't even talk to you. So then you'd have to go to court and have the court-appointed administrator or executor to be able to get that. With a trust, you have the two trustees, and if one trustee is unavailable, the other one does it by themselves. If they're both unavailable, then we appoint a successor trustee. And it's not hard to do. You have a death certificate and some paper, and you do a affidavit of death of trustee. And now the new trustee, successor trustee, is in charge. So that new trustee can go into the bank and say, here's a copy of the trust, here is the death certificate, here's my affidavit of death, and here's a new tax ID number. You need a new tax ID number when both parents die or both parties die, because you can't use their socials anymore. And the bank will help you out. And the bank will open up a new account in the name of the trust, transfer the account into your new account. The court isn't involved, no probate, it's private, and it's done pretty quickly if everything is done correctly. Now, as far as your house is concerned, most married couples take their house as husband and wife as joint tenants, okay? Or it could be community property with the right of survivorship, but we normally see joint tenants, which means if one person dies, the survivor ends up with the house, but you have to file an affidavit of death and a death certificate. It's 2 or 3 pieces of paper, and the deceased person's name is removed. So now it would just be survivor. That's easy, but what happens when they both die? That's where the court would get involved, because if it's in the name of Bubby and Zadie and they're both dead and it's not in the name of a trust, who's going to sign a deed to sell it? Got to go to court. In a trust, we just appoint a new trustee. Very simple. And it's court, again, no court involvement. So what we do is we transfer the house by the way of a deed. We can transfer non-retirement bank accounts. We could make the beneficiary of your life insurance policies the trust. So the trust now collects on the policies, and then can use that money to pay bills, and then distributes to the beneficiaries when it's appropriate. Any investment accounts like you have at Morgan Stanley, Schwab, or whatever, that can go in there. Retirement accounts go by beneficiary designation. You don't want those going through the trust because they are taxed differently. If you inherit an IRA, under the current law, you have the recipient or beneficiary has 10 years to take that money or spend that money. It's called the Secure Act. The law changed on this, I don't remember, 5 years ago, I think, 2019, 6 years ago. And it used to be if you inherited an IRA, there was a formula about how many years you had to spend it and whatever, and based upon your age and a few other things. Now it's 10 years. So you could spend the inherited IRA first year, or you can wait for 9 years and 11 months and spend it then. So those go by beneficiary. You do not want those in the trust. If you have 401ks, if you have public retirement systems, all these retirement things usually go by beneficiary designation, not through the trust because of tax reasons. Yes, ma'am.
They're tax-free when they're the beneficiary.
Thank you.
They're not tax-free. That's retirement account.
Wait a minute, wait a minute.
The 10 years, does that apply to 401K?
If it's in, well, no, that's a beneficiary designation 401k. I don't think so. I think it's by
But so
only
is
IRAs.
the
I think it goes with.
but so is the IRA.
It's my recollection. It is inherited IRAs. Okay.
Not
I don't think
401K?
about 401ks, but I'll check. Remind me later.
That would
and
be
I'll check.
good, Elliot, to know. And also, oh gosh, I just forgot can it be rolled over into another investment
if
and not
it's-
be spent in 10 years?
If it's a spousal, yes. If it's not spousal, it's got to be taken in 10 years.
Okay,
Okay,
not
you want to
rolled
roll it
over.
into something else, you can, but it has to be taken out in 10 years. Google,
But when you say taken out, you mean spent?
yes.
Okay,
I
so
have to
it
take it
cannot.
out, wait, I have to take it out of the IRA account, make a distribution to myself, okay? Just like you do now over age 73. You have to take out a minimum.
a
Here you
distribution,
need to
yes.
take out all of it in 10 years.
Okay,
And if you don't, I believe there's a 50% penalty plus the tax on it.
and then, so that is not, those monies cannot be rolled over into another form of IRA.
If it's an inherited IRA and it's non-spousal, you have to take
Okay,
it
I
out
get
in
it, I
10
get it.
years. If you Google, I find sometimes even myself, Google Secure Act, and it'll explain it in more detail, okay? Now, Ron, what was your question? Taxable? If it's an IRA, a traditional IRA, you have to pay income tax on it. So if you get $100,000 is the gross amount, what was the basis? And you're going to have to pay income tax.
The beneficiary.
The beneficiary pays the income tax. That's correct. So one of the advantages, you could take all $100,000 in 1 year and pay it all in 1 year, or I can take it $10,000 a year for 10 years and pay the tax on the $10,000 every year and let the rest of it grow. But it is the beneficiary's choice what to do on that. But it has to be taken out in 10 years. Yes.
Okay, Elliot, on your chart, you have investment accounts with an arrow into the trust,
Yes.
but not the IRAs and the Roths
Right.
outside. So what investment accounts?
Let's say you have a Morgan Stanley account.
I do,
Okay. Is it an IRA?
yes.
Okay, then
And a
it doesn't
Roth?
go into trust. Trusts are all, Roths have already been taxed, you paid for after tax, so those are different. Retirement accounts go by beneficiary designation. You can have an investment account at let's say a brokerage that is not a retirement account.
Oh, right, just a
So
brokerage account.
you would open you would open Bubby and Zadie would open the Bubby and Zadie account at Morgan Stanley or whatever, and that's their investment account where they have stocks and securities, mutual funds, or whatever. That would go by in the trust to be distributed to the beneficiaries. If it is not and Bubby and Zadie die, then you're in probate, and we want to stay out of probate. Yes, Judy?
So does it make sense to give your charitable contributions to organizations out of your retirement? Because they don't have to pay tax, correct?
I'm going to get to that at
Oh,
the end, okay? I'm going to get to that at the end. So what you do want, like I said, what you do want to transfer into the trust are these items. Now, again, let's pretend Zadie dies first, then Bubby is going to be the sole trustee. So she's in charge. Now, she dies or wants to retire, resign, then she could resign and appoint, we'll say, son, okay? So the son becomes the trustee, and basically just a new manager. And that's how you avoid court. The only time the court is involved is if there's a dispute. And then what you would have to do is, if there's a dispute, there's a petition filed in the court, and the court takes jurisdiction. But if there's no dispute, court has nothing to do with it, all right? Now, in the estate plan, we have different documents that we use. I talked about the trust. I want to talk about a pour-over will. What we want to do is we want to transfer our assets to the trust. Well, let's say when you die, you forgot to transfer an asset to the trust, and it's still in your name, and you die. What do your heirs do with it? Well, the pour-over will pours it into the trust. However, in the real world and today, we can get around that by doing what's called a Hegstead petition. What a Hegstead petition is, in our trust, it says, I intend all of my assets to be part of this trust. And if I forget to put one in, then you go to court and you ask the court, look, the trustor intended that all of his or her assets would be part of the trust and just forgot to do this. And we want the court to issue a court order. It says the property is in the name of the trust. How this comes up, and this actually comes up a lot. You have your property in your trust and you want to refinance it. The bank says to you, we don't make loans to trusts. So what you have to do is they make you take your house, put it back into your name, make you the loan. And 9 out of 10 times the people forget to put the house back in the trust and then they die. So what happens is they die, somebody calls me and says, the house is in escrow and they just found out it isn't in the trust. And I always think to myself, what the hell did your real estate broker do doing this without checking to see if the house, even if you own the house? But okay, another story. So what you have to do then is we file a petition in court, Hegstead, and we say, look, it was in trust. They took it out to refi it and forgot to put it back. So we're asking the court to give us a court order that says that house belongs to the trust. And that's what they do, and now you could sell it through the trust. Now, that's not a probate, but it still costs in today's world approximately $6,000 and 30 to 60 days to get done. Okay, and you can avoid that if you just do it right. But I get a little, in my older age, get a little testy when I see, why in the hell didn't they tell you to put it? They took it out. Why didn't they put it back for you? Well, that's not our job. So what happens? So I'm telling you the advantages of having a trust here. Disadvantage, it costs more to set it up. It depends on the trust, how many people are involved, how many properties you have, what is your estate. If mom and dad come in and say, well, the only thing we own is a house, we have an investment account, we have life insurance and a few things, that's going to be, maybe one price. Or, if they have 10 kids versus 2 kids, that may have something to do with it. But yeah, it costs more money to set up. But if you have $1 million estate, it's not going to cost you $23,000 to probate it. If everything goes well, it could be, I've done some, everything goes smoothly, $2,000. I had a couple, I did a trust for them about 20 years ago, and they, both of them coincidentally died within a week of each other during COVID. But before they got to that point, they realized they couldn't handle things, so what they did is they resigned as trustee and appointed their daughter. So I transferred everything to the daughter as trustee of the trust. And then the daughter was able to take care of mom and dad, and then mom and dad died. And so when it was time to administer the estate, matter of fact, I just spoke to the client about a week ago, and she said, this went through so easy. She hired me. She gave me a retainer of $2,000, and when it was all done, I gave her $500 back because everything went through so smoothly, I didn't have to do anything. And she has 2 siblings, I believe. Everybody was on the same page. Everything was done because we had set it up before the parents died. And she was able to sell the parents' house, paid off the bills, and made her distribution in less than 4 months. Now, under the probate code, the trustee is required to give all beneficiaries and heirs a notice that says you have 4 months if you want to contest this trust. So the trustees can't do anything. I tell them, do not distribute anything until that 4 months goes, because if you've distributed and then there's a contest and you've already given the money away, you're not going to get it back. However, we go to the beneficiaries and we say, look, she's willing to distribute now, but you need to waive the 4 months. I've never had anybody say they wouldn't waive it. And so instead of waiting 4 months, we get it resolved. It could be in 2 months. Let's say mom and dad died with no real estate, just a bank account. And trustee pays off their bills. I always tell them leave a little bit in reserve for next year's tax return, but get the 4 months waived, and you could distribute to your siblings right away.
Yeah.
And that's sort of what happened in this other one. And the fees were around $1,500 versus
Elliot,
Caribbean.
I have a question on Zoom. Are annuities considered?
Say again?
Are annuities considered?
I can't hear you, Jerry.
Oh, are annuities considered? Annuities.
Annuities, well, it depends. If it is a retirement annuity, you want the beneficiaries to be the individuals. If it's a non-retired, say a non-qualified annuity, that's what it's called, when it's not retirement funds, then you can name the trust as the beneficiary. Okay? Now,
Question?
yes.
So would you always put your bank accounts in, even if they have payable upon death
No,
beneficiaries?
that's like a beneficiary account. So you could have a pay on death or pay on death account. But here's what happens. Mom and dad put all of their bank accounts in pay on death to their children. And the investment accounts, bank accounts, or whatever. Then there's a death. There's no cash to administer the estate. You come in to see me, I said, I want a retainer of X number of dollars. Your accountant's going to want something to do the tax returns. You're going to have to rehab the house in order to sell it. There's no cash because it's already been distributed to your siblings, so to speak, if that's the case, and they've already got their money. And now you're the trustee and you say, look, I need $10,000 to get the house ready to sell. And they say, hey, well, yeah, I'm sorry, I've already spent that $10,000. So you may have a house worth $1 million with zero cash. Now what do? You're the trustee, and you've got to hire a lawyer, you got to hire an accountant, and you've got to do some work to get it ready for sale. And you got utilities and insurance to keep paying until you sell it. But there's zero cash in the account. And again, many, many times, once that money goes and it gets in the hands of the beneficiaries, you're not going to get it back. So that means the trustee advances it out of their pocket and has to wait for the house to sell to pay themselves back. So you can do it with a pay on death. But if you have pay on death to your children, what if one of your children die before you? Now that deceased child's share, that could possibly have to go to probate, depending on the amount of the account, of course. But I do tell some people, if you want to do pay on death, but make sure there's enough cash in the estate to cover expenses. Okay?
Question.
You made a statement. Microphone.
Yeah, you made a statement that 4 months can contest the trust. I'm aware that one can contest a will. That will can be contested by anyone, but I thought trust cannot be contested.
Not true.
Not true.
Trusts get contested all the time. I had one recently where it was a forgery, okay? Somebody brought a trust and said, that's not Dad's signature, okay? Or what's more common is this happens a lot, folks, one child would take mom or dad to a lawyer or a paralegal, and they do a new trust and disinherit the rest of the family. Happens a lot, okay? And the disinherited group says, Mom was incompetent at the time, you unduly influenced her, she didn't know what she was doing, she had no intention of disinheriting all of her children but you. So that's how you contest a trust. You have 4 months to do it. Well, you have to file a petition in court challenging the trust, and then you could have a trial on it and evidence, and you get the doctor's reports that said Mom was incompetent at the time. My practice, people come into me all the time. They may bring their elderly parent. My policy, and most lawyers, I kick everybody out of the room except the client, and I usually bring in my assistant to take notes. I don't want anybody there influencing this person. I am thinking of one in particular right now. I had her daughter sit outside. Myself and my assistant interviewed her for about half hour, 45 minutes, talked to her. I'm no psychologist, but I asked her, where'd you go to high school? Who was your high school boyfriend? Who's the president? I had one guy. This was during Reagan's time, I remember very well, and Boyd Briskin was involved in that one. And I asked the guy, who's the president? And he said, the guy that dyes his hair, the actor. Okay? Then I said, what color's an apple? And he said, what kind of an apple? And I said, what do you mean? He said, well, there's red apples and there's green apples. Which one are you talking about? So I got the impression he knew what he was talking about. I've had some people that, you ask some questions and you could tell they don't even know where they are. And I'm not gonna do a new trust for them. But my policy or procedure is I kick everybody else out of the room, and I want to talk to you directly. Why are you doing this? Why are you disinheriting your youngest son? Tell me why. Well, he's a drug addict and he lives on the street. Okay, all right. Has anybody told you to do this? No. Your older son is out there. Has he told you here? No. The only thing is I wanted him to drive me because I don't drive anymore. Okay, but I'm very careful about this. I don't want to get sucked in later on and be a witness. That's why I take notes and have a witness, have my assistant with me. We compare notes. You think that this person knows what they're doing, that sort of thing. Okay, let me move on a little bit. I want to talk about for a second durable power of attorney. Okay, consider a durable power of attorney should be called a durable power of authority. Okay, what it is a written document that says I authorize someone else to act on my behalf. And if it's durable, it means if I become incapacitated, it is still good. It survives my incapacitation. A common, or I want to say common or normal, I don't guess, power of attorney, if I become incapacitated, that authority is no good. But if it says durable on it, then it is. Now, sometimes we use these. We don't use them that often. Most banks, title companies, and everybody else doesn't like using powers of attorney because there's so much fraud involved. But it's part of the estate plan we use. Next one I want to move over to is Advanced Healthcare Directive. I sometimes think this is the most important document of all of these things, because what are your wishes if you become incurably ill? Or you get injured and you can't make healthcare decisions. You don't want family members fighting each other over what mom and dad wanted to do or what mom wants. There's, in the power of attorneys, or advanced healthcare directives, I'm sorry, the one I use the California Medical Association form because doctors are familiar with it. And in that document it says, there's a statement on page 3 that says, if I'm incurably ill and my death is going to happen in a matter of months, this is what I want. Option A is basically keep me comfortable and let me die. So option B says keep me alive with medically accepted or with generally accepted medical procedures or whatever, which means feeding tubes, respirators, and whatever it is. I would say 95% of the people take option A. Nobody wants to be kept alive on a machine. Some people say, then the next page of the form says, do you want to be an organ donor? So a lot of people think, well, I'm afraid they're going to unplug me too quick so they can get my organs. So, well, it's not that easy. It doesn't happen that way. But I think it's very important. And again, like I said, I've been doing this a long time, and I've got a story for everything. I had one case where the grandma, I did a power of attorney for her, and she said, if I'm incurably ill, let me die. And she had a stroke. And the older brother, who was my client, basically told the doctors, we're going to have to unplug her. She had a stroke. There was no brain activity and whatever. And then the younger brother is having there'll be a miracle, oh God, and whatever. And they're having a big argument. And the older brother says, this is what Mom wanted. This is what we're doing. So they unplugged her, and she lived for 8 more months on her own. She never became conscious, but she was breathing, and her eyes could follow you, and they could feed her. She never communicated, but she was alive for 8 more months. But it saved stress and strife in the family. Okay, let me move on to, this is a biggie. I think it's on the top of page 2. Taxes. Everybody asks me, what about taxes? Now, I'm going to make an assumption. If I'm wrong, then I'm wrong, that nobody in this room has over $28 million to give away. If you do, that's another story. But right now, the federal estate tax exemption is $13.99 million a person. Now, this law is set to expire at the end of the year. And the big, beautiful bill that is pending is to extend the federal estate tax exemption for permanently. This one came from the 2017 Trump Act, and it expires the end of this year, and they want to extend it. So unless you have $28 million, you don't have to worry about estate taxes. California does not have any estate taxes. But then we have other taxes. Let's talk about capital gains and stepped-up basis. This is very important. One of the advantages of dying is your heirs get a stepped-up basis. That's what I tell people. What a stepped-up basis is this. Let's say Bubby and Zadie bought their house for $100,000 20, 30, 40 years ago, and it's now worth $1 million. If they sold it today, they get a $900,000 gain. And they get a credit. There is a federal credit, I think, of $250 per person, but they have a $900,000 gain. If Bubby and Zadie gave me the house during their lifetimes, I take it with their basis. I take the donor's basis. So when people come in and say, I want to give my kid my house, I say, don't do it. Because when they sell it, they have a $100,000 basis, and it's worth $1 million. If you inherit it, the basis steps up to the value as of the date of death. So if any of you have ever been involved in any probate or trust administration, one of the things the lawyer is going to tell you is you need to get the property appraised. Now, bank accounts are easy. Investment accounts, that's no big deal. And I'm not worried too much about personal property, but you get the house appraised. And the house is now worth $1 million. So the heirs inherit it with $1 million basis. Now, if the trustee sells the house for $1 million, there is 0 tax. Okay? Now, let's say at the date of death the house is worth $1 million. I can write with this, and you sell it for 1.2 a year later. Sometimes the house doesn't get sold right away. Well, there's a $200,000 gain. The estate or the trust is going to have to declare a $200,000 gain because the property went up in value from the date of death. Now, by the time you pay real estate brokerage commissions, you pay maintenance, repairs, and whatever on the house and whatever, you may have enough deductions to cut that way, way, way down. I had a case some years ago where parents died, house was worth whatever it was, and they didn't sell it right away. and I don't remember the reason why, but they held on to it for a while, and they sold it 2, 3 years later. In the meantime, the house went up in value like 25%. And then they sold it. And so the guy had, I think this was a probate, if I recall, he had a capital gain of X number of dollars. And he got mad at me because he had to pay taxes on this. I said, you only pay taxes on the gain. And he was yelling and screaming at me, and I said, I'll tell you what, give me the gain, I'll pay the taxes. And he hung up on me, okay? You know, so if you made $200,000 and you got to pay tax on $200,000, I say, but you got $1 million tax-free. I would gladly pay taxes on that to get a $1.2 million asset. So, okay, so that's capital gains. The next thing is income tax. Now, if you're administering a trust or even a probate, you're responsible to file a tax return for the deceased if one is necessary. I always tell people, talk to the accountant. You know, I'll ask them, did your mother file tax returns last year? No, she never had enough money to do it. So then probably you don't have to do it again, but you need to check on it. But let's say you have an estate that has investment property, or the investment accounts are making a lot of money or whatever, then it is possible you may have to pay income tax on the income of those investments during that year. But that's an accountant's question that you'd have to talk to. But it is possible. It's a client of mine that's managing 8 rental properties. Yeah, he's going to have an income tax return because these rental properties are bringing in money every month. So that's another tax. Now, the last one on my list is the property tax. This one bothers more people than any of them. Prior to Prop 19 of a couple years ago, children who inherited their parents' real property would keep their county tax assessment. So again, if Bubby and Zadie bought a house 40 years ago in Riverside, their taxes might be $1,500 a year. That house being worth $1 million now, the taxes go to $12,000 a year, figure 1.2, 1.25%. But if you inherited, in the olden days, their house and kept it as, let's say, a rental, or lived in it, kept it for rental, you would keep their tax assessment. Prop 19, a couple years ago, changed that. Unless it was Bubby and Zadie's primary residence, and I am going to live in it in my primary residence. If that's not the case, taxes are going to go up to the value as of the date of death. And people just go nuts over that. That $1,500 tax bill is going to go to $12,000. It used to be if they had rental property up to a certain amount, there was a limit on it, then you would keep the old base, the old assessment. Now you don't. I had somebody, property was in Long Beach, and it was paid for in the family for years, and it was a rental, and it was bringing in like $4,000 a month. And when the client found out that the taxes were going to go up, first thing she says to me, I might as well sell the house. And I said, wait a minute. Her name was Ruth. I said, Ruth, wait. You're bringing in $48,000 a year. So if your taxes go up to $1,000 a month, that's $12,000. You're still making $36,000 a year on an investment you got for free. Why would you sell it? Oh, didn't think of it that way. Now, what will happen, let's say there's a mortgage on the property. Then you'd have a problem. You know, we got a mortgage on it, we've got this, we got that, and if the taxes go up $1,000 a month or whatever, maybe you can't afford it. Maybe it doesn't pencil. But a lot of times we'll come in, mom and dad's house is paid for, and the kids want to keep it as a rental, or they want to keep it in the family as, you know, a homestead or whatever. And the taxes are going to double, triple, quadruple. And they think, well, might as well sell it. Wait, let's do the numbers. You're still making money on it, and it's appreciating. Why do you want to sell it? Oh, yeah, I didn't think of that. That's a good idea. So, but that is really an issue. that really bothers people more than I think any of the other taxes. I've had people try, how do we get around it? Well, you're going to sign under penalty of perjury that it was mom and dad's house, and you're signing under penalty of perjury that you're living in it. Well, how do I prove that? Okay, well, I don't know. I'm not telling you how to commit fraud, but you have to be careful. But that is a biggie. Okay, now, are there any questions up to this point? Okay. Tim, you need the microphone.
On the bank accounts, does the trust need to be the bank account holder?
The account holder would be Bubby and Zadie, trustee of the Bubby and Zadie's trust dated June 11th, 2025. A successor trustee would be Elliot, successor trustee to
Right.
the Bubby and Zadie trust dated June 11th, 2025.
So if the trust is not on the actual bank account,
Then it's not a trust account. And the banks are very particular about that. So if the account said Tim Beld, not in trust, and you die, then we got to deal with it. Okay. Again, I have a story for everything. I had a couple, they had been married 50 plus years. Husband, many years ago, bought a CD at a bank. I remember it was Farmer Merchants Bank in Long Beach. And he kept rolling it over. And when he died, there was $185,000 in it, in his name alone, and not in the name of the trust. The wife didn't even know about it. And he just kept rolling this thing over for probably about 30 years, 20 years, I remember. And it wasn't in trust, and it was $180,000, and it was above, there's a limit that you can avoid probate, and he missed it by, I think in those days it was $175,000, and this was $185,000. And the bank, nope, it's in his name alone. His name alone. Yeah, but it was supposed to be in the name of, nope, his name alone. We had to go to court, do a Hegstead petition, have the court declare that account was part of the trust. But I've had that happen many times. Somebody will come in and say, my spouse had an account, didn't even know about it. Yes, yes.
So, 2 questions. Are you saying that CDs should be in the trust?
Yes.
Okay, and another
Now,
question is...
I'll answer that this way. You could have a CD pay on death to somebody, just like I said before about a bank account, but that means if the trust doesn't have any other liquid assets, they have no money to operate the trust. So I tell people, make the CD part of the trust. So the CD, the title would be Bubby and Zadie, trustees of the Bubby and Zadie Trust, and you always have to put the date of the trust on. That's the birth date. You go to the doctor, they ask you your birth date. Name of a trust is the birth date of the trust, and that doesn't change. So it keeps it separate from any other Bubby and Zadie trust out there.
So what would be the advantage, then, of having, let's say, my daughter on a bank account with the CDs and the cash?
Then she would have, well, if she is not trustee of your trust,
She
then
is trustee, yeah.
Is she
Yeah.
a current trustee with you?
Yes.
A co-trustee?
Yes.
Well, what would be the advantage of not having it? I mean, at least, do you have one child?
2, but she's the trustee.
Okay, so you want her as trustee, or you want her on pay as death?
I don't know about pay and debt. I'm not familiar
Well,
with
then
that
she should,
term.
well, if it's in the name of the trust, then if it would be, I don't remember your name, but you and your daughter co-trustees of your trust.
Right.
And the bank would want to, when you open that account, wanted to see your trust,
Yeah.
probably had you sign a trust certification.
Right, yes.
And they wanted a tax ID number, which was probably yours. And they wanted your daughter there to get her signature on a
Yeah.
card. And basically, it's a co-trustee account, and
You
either
did
one
it.
of you can
You
have
did
access.
it for me. Yeah.
What?
You did it for me.
Oh, I did.
Sherry Bachman.
Okay.
Okay.
Like I said, never mind. I'm sorry.
What? Oh, microphone? Okay. Well, that's part of my question, is how to get more specific things into the trust. I have a trust, but it's not specific enough.
Like personal property?
Personal property and bank stuff, too.
Okay. Bank accounts, again, non-retirement accounts,
Yeah.
should all be titled in the name of the trust.
So how do you do that?
You go to the bank with your trust,
Okay.
and you say, do you have did I do yours too?
No. Pardon?
This one's on? Okay. Do you have a notebook?
What, dear? I'll take this one. Okay, thanks. It's in a, well, yeah.
Like,
sort
okay, what I tell my clients, take the notebook to the bank
of. Okay,
and say, I want to put this in trust.
okay.
The bank officer will go through it, copy what they want,
I can do that.
and, you know, people ask me, what do I take? Take the whole notebook.
Mm-hmm.
Because if I tell
Yeah.
you to take one thing, you'll forget it.
Yeah.
Just take the whole notebook. It should be there. The first part of it should say trust. My notebooks will say trust, and the second one says wills, and then the third one might say other trust, and then it'll say powers of attorney and whatever. So there'll be a tab there. So I just say, take that. So you want it in the trust so the trustee can manage this upon your death. Or you haven't died yet. Now, of course, a question about pay and death. I didn't mention this. You don't die yet. You have a stroke, and you can't access that money because it's only payable on death to your beneficiary. And you need that money to pay your bills. How do you get it? If it's in trust, your new trustee comes in and gets it. So that was one of the things I didn't mention. If you have money in a pay and death account and you need the money but you're unable to get it yourself, they're not going to pay the beneficiary because you're not dead yet. So that's a disadvantage.
So
I didn't mention that.
the second part of my question was, how do you get your personal property
Okay.
to be more specific in the trust when it isn't now?
You add it to the trust. It's very easy. You do a list.
Oh, with a list and what you
make
do?
You make a handwritten list, and you say instructions to the trustee.
Oh.
Okay? Matter of fact, your notebook may even have something that says special instructions or something in it. And you write, to the trustee, distribute my personal property as follows.
Oh, okay.
That's all there's to it. And then you give it to your trustee or make sure the trustee can find it. A lot of times I will put in a trust, personal property shall be distributed pursuant to a list, and then it turns out that people die without a list. But if you want, you know, I leave this microphone to someone and I leave this pen to somebody else, write a list, attach it to your documents, instructions to trustee, distribute the property as follows, and sign it and date it. That's all you need to do. That's legal.
You don't need to have it,
No.
great.
You don't need it notarized
That's
if
the
it's in your
point.
signature. The only time you need it notarized, actually, there's no legal requirement that a trust needs to be notarized, okay? But everybody does it, but there's no legal requirement for it. The only time it is an issue if someone says it's a forgery. So if someone's going to say that that list was not signed by you, but I usually don't worry about it. Now, sometimes when I make the trust, people will say, okay, I want these specific items, and I'll put it in the trust. But then you die. By the time you die, you don't have those items anymore. Sometimes people say, I want to leave my 2020 Honda to so-and-so. I say, well, you're not going to have that when you die. Just say the vehicle that I own when I die goes to my grandson, instead of pointing out which one it is, because you may not have it. But personal property, just make a list. Give it to the trustee. Is he your trustee?
What?
No.
Oh, okay. Whoever your trustee is.
Yeah, you are. You and Jana.
Okay.
He is.
Okay. So let me move on from any other questions. Yes.
Yeah, going back to the cost basis on a home, inherited exemption on capital gain. You said it's $250,000 a person?
My recollection is $250 per person, $500 per couple, isn't it? Yes. If you sell your home, you have to live in it, 2 of the last 5 years? And you get an exemption.
Okay, is there another one for like a one-time exemption on capital gains from your personal residence?
I think that's it.
That's it, huh? Oh, okay.
Yeah, that's not one time. You can do that, I think, every 3 or 4 years you can take that exemption if you buy another house.
We have never taken it.
We haven't sold your house yet.
No, but
But if you,
the capital gains is a lot more than that.
capital gains, what I say usually a third, 35%, state and fed, depends.
Okay.
But still, on this, $1 million house with a $100,000 basis, you give me the house during your lifetime, I take your $100,000 basis, I sell it, and I get $500,000 exemption, I still have $400,000 in capital gains. Yes, that's our situation. Yeah, and that's $135,000 if it's a third. So, like I said, I said before, I make a joke out of one of the advantages of dying. Your heirs get a step up. So, I really discourage parents giving their houses or properties away during their lifetime. And one other thing, super discourage putting your kid's name on title. Oh, I put some kids through college because of people that did that. Here's what happens, and I've had this happen. Mom dies, dad's distraught, dad has one daughter, puts her on title because if he dies, then she gets the house. Well, guess what? Dad gets a girlfriend a couple years later and gets remarried. And he says to daughter, I want to sell this house because me and new wife want to buy a new house. And daughter, I swear to God, gives dad the middle finger and says, no, it's my house. You gave it to me. And dad had to sue her on the basis that this was not intended to be a present-day gift. It was an estate plan technique to become effective only when he died. And happens a lot. How about this one? You put your kid on title and your kid has a tax lien. That's a lien on your house. Okay? Again, another story. I had recorded a judgment against a guy named John. And I get a phone call, this goes back 20 years ago, I get a call from John's son who is yelling and screaming at me that I have a lien on his house, on the son's house. I said, what are you talking about? You've got a lien on my house for X number of dollars. So I don't even know who you are. He says, you know my dad, John. Yeah? Well, your lien is on the lien you have against him's on my house. So I said, how did that happen? And the guy is really brilliant. He says, well, I was going through a divorce and I was trying to hide property from my wife, so I put my dad's name and title to my house. By doing that, the judgment I had against dad applied to his house. So, the guy's screaming and yelling at me. He's going to come beat me up. He's going to report me to the state bar. I said, go ahead, John Jr. You go ahead, report me and tell him that you were trying to defraud your wife by putting the house in your dad's name, but it was really your house, and now you're pissed off because I got a lien against it. I said, here's the phone number of the state bar. Call him, and here's my bar number. I eventually got paid, and for years afterwards, something came up, and they remembered me. But don't put your kid's name on title to the house. I've had situations where this happens, and another one where kids, parents put the child's name on title, and when the child, owed child support or owed something, and it's a lien on the parent's house, and you're stuck with it. So don't do that. Let me move on. I was talking about now plan giving. I've had a number of questions, and I have people that come to me a lot that are putting together estate plans and talking about charitable gifts. I've had somebody did the City of Hope recently. I had, I told you, Guide Dogs of America a few years ago, and I had somebody, there was a veterinary clinic. I remember this one client only took her dogs to this veterinary clinic in Fountain Valley. For some reason, I don't remember why, and she left money to them. I've had people that have left money to the temple. In fact, I've been requested to discuss qualified charitable distributions. And what that is this. If you have an IRA and you need to take a required minimum distribution, so let's say your minimum distribution is $10,000. There's the whack one. So if you have a RMD, $10,000. and you're required to take that. If you take that, that is $10,000 in income that is added to your adjusted gross income, and you have to pay tax on it, right? What you could do with a qualified charitable distribution is you can assign that $10,000 to a charity, okay? Whatever charity you want. Let's use TBE because that's where we are. You could assign that to Temple Bethel, and you tell the administrator or custodian of the IRA, pay TBE my minimum distribution. Temple gets that tax-free, and it is not added to your AGI, so you don't have to pay tax on it. And you can go up to $108,000, I believe, per year that you can donate that way. It doesn't have to be to the same charity. You could take that IRA distribution or your minimum required distribution, and you could spread it out amongst multiple charities. But the idea is, since you can't have control of it, if you get a check, it's yours. You need to declare it. But if it's paid directly to the charity by the custodian or administrator, it never touches your hand, so to speak, and you do not get taxed on it. Yes, ma'am.
Two things. What's the 108,000?
That's the maximum you can do.
Out of your RMD?
Well, no, you could out of an IRA. The RMD is what people do,
Right,
but you are allowed to go. You can distribute
Up to?
up to 108,000 of IRA money
Okay.
that way per year.
So my other point is that when I worked at UCR in the development office, you do not get, I mean, the one who assigns to Temple Bethel does not get credit for that gift. It's the RMD that gets credit. It's Fidelity that gets credit, with your direction on it. And that's
right.
People.
Yeah, so it's not reported
Correct. But
on
it's
your
not-
tax return. If you take the money,
Right.
it
And
is
then-
added as part of your adjusted gross income, and you pay tax on it. Then you can, then if you want to get if you want to go beyond the standard exemption, you have to do an itemized return.
Right.
Okay, but if you do it with this method,
Right.
it goes directly from the holder of the money to the charity, and it never hits your bank account
Right.
or you personally. And so the charity gets the money. It does not get reported to the taxpayer or the donor.
Right.
And a lot of people do it. Okay, and like I said, you could use, it doesn't have to be your RMD. It could be any IRA money. Now, SEP IRAs and simple IRAs are eligible as long as they have been inactive for a year. In other words, there have been no distribution or no contributions to it. So if you had a SEP or a simple from your employer and you're retired, then that would be okay because you're not getting any more from it, okay? But I understand that I know some people that have done this for other entities, and I know I have people that say I really don't need the minimum distribution, and if I get it, I'm going to pay tax of a third or 25% or whatever. And this is a vehicle to get money to a charity that doesn't cost you anything.
Right. But what we do is when we have our dues to pay to Temple, we do it out of the RMD.
Great idea.
Yeah.
Great idea.
Yeah.
I got to think of that myself.
Do it.
Anyway, so like I mentioned in my outline here, the benefits are avoid tax on distribution. There is no tax because you don't have the money. Reduce your taxable income. You don't have to declare it. It meets the RMD requirements. We just talked about that. And the donation to the charitable organization is without incurring tax consequences. So if anybody was interested in doing something like that, then you can talk to Jory. I'm not here to promote donations to Temple or anybody else. I'm just mentioning it. But it's something to think about. And I know the Temple can use the money, I heard. But anyway. Okay, so any other questions we have now? I think I've covered everything. Yes, sir.
Isn't the personal items, like Carol Lee was mentioning, isn't that part of pour over will kind of thing?
You don't want the pour over will because that's a probate. It's
Oh, yeah.
The pour over
Well,
will is like a safety net.
That doesn't go into the leftover Or stuff that goes into the trust.
Yes, but but if it's personal property, it's, my pen isn't
Yeah.
registered anywhere,
Yeah.
so it just, on paper, I say it goes to the trust. I wouldn't worry about that.
Okay, I see.
Where we talk about pour over would be, again, let's say you had a bank account or a house. I've had people, they bought a house, forgot to put it in the trust. Now with Hegstead petitions, which we didn't have, I think Hegstead's probably 15 years now, but you'd have to go do a pour over will. I have only used the pour over will once in my entire career, and it was for the guy that I gave the money to, the Guide Dogs of America. And what had happened in that case, he loaned somebody like $500,000. And in order to sue to get that money, we had to open a probate and have an executor appointed to be able to sue for the money, because it wasn't part of the trust. And so what we did was, when we sued, got the payor to pay us, we deposited it in the trust, and then we dismissed our probate petition. It's the only time I've ever had to use a pour over will.
All right, so all other items, personal speaking, just a list and add it to the trust. This
And
is
if you look on the Exhibit A to most of your trusts, it might have a statement that says, I'm transferring the property listed on this exhibit plus any other property I own. Or you could have sometimes a separate form that I use a separate form sometimes. It just says assignment. I hereby assign all personal and real property owned or presently owned or owned in the future to my trust. So if it ever had to do a Hegstead petition, you could go to the court and say, look, it was his intention that everything belonged to the trust, and he just forgot to put it in. Okay, and Hegstead petitions are done. They're called 850 petitions now because they're under probate code 850, but they're under the case of Hegstead, Heggstad. If anybody wants to Google Hegstead, you'll see what I'm talking about. Okay. Anything else?
Thank you.
Yes, Judy.
This might be simple, but if you have property that you want to give to a specific organization, like I have artwork that I would like to send to a specific place, can that be just an addendum that I put into the trust?
Yep. Just write a list.
Okay.
Instructions to trustee.
Okay. So okay.
Yeah, it's personal property. Instructions to trustee. The following personal properties be distributed to,
Okay.
and describe what it is. I had a lady once who put stickers. I swear to God, she's the mother of one of my best friends, and she took a sticker, and on everything in her house, she put someone's name on it. And she said to the trustee, which was my friend, give to the people all the stuff, the names on the sticker. And so it's kind of easy. Okay, this goes to Cousin Joe, and this goes to whatever. And we just, yes.
So you don't need to see a lawyer to do all this. You can do it yourself and add it to your notebook.
Just write. Oh yes, just put instructions to trustee.
Okay.
And should you date it?
And sign it and date it.
And sign it and date it.
Yes, the trustee. I'll tell you what too. In the real world, trustees will enjoy that because then they don't have to decide who gets this stuff. Okay. I've had people fight over the black pen. Well, wait, look at the trust. Mom said that it goes to Cousin Joey or whatever. And so if you have artwork, jewelry, other personal property, things in the house, then if there's instructions, if I'm representing you as trustee, this makes your job easier. You don't have to decide where this stuff, you don't have to go out and sell it. You don't have to do estate sale. You just give it away. Now you'll find out in the real world, unless it's artwork or jewelry, most of the stuff that's in the house, most people don't want. And, I don't need mom and dad's old couch and the thing that my parents had for 30 years or something. And I can tell you from experience when my parents died, I got a refrigerator for my garage, and I got my dad's ladder and some tools. I didn't want anything else. My mother had sheets and towels from when we were kids, saying someday you guys may need them, so she saved them. Okay, And my dad was a computer nerd, and he had all these old computer parts and boxes of hard drives and this and that and this, and they were probably all outdated. That's why he stuck them in a box. But I didn't want to give them away because I thought they had some value, and I had someone look at it and say they have no value. Now what do you do with them? We got a dumpster, and we filled up the dumpster twice. So if you give instructions to someone that says, here's how to deal with it, it makes the trustee's job a lot easier, okay? And then you don't have people fighting over, well, Mom promised me the cookie jar. I literally had one once with Mom. They fought over the cookie jar. I had one fought over pictures. You know, they were fighting over pictures. I said, make duplicates. Didn't think about it. Yes?
So how do you do the pay on death account thing?
Well, I don't like pay on death accounts. But if you want to pay on death account, you go to the bank and you open an account that says pay on death this account to so-and-so.
Why don't you like it?
Because then there's no cash in the estate. Possibly you have no cash in the estate to pay bills if you leave
Oh.
all your money on pay on death.
Oh, so it would be distributed upon your death?
Well,
Oh, okay.
yeah, and then I
Okay.
don't like pay on death because if you fall down the steps and have a
That's-
stroke, whatever, I'm your trustee, I can't get that money because you're still alive, and I need that to pay your bills.
That's
But if
why you
it's-
didn't do it.
But if it's
For
in,
me.
if it's in the trust, then the trustee, the successor trustee has access to it.
Okay, gotcha.
So, you know, I've had situations where parents will say, okay, we've got these accounts, there's a lot of money here. That's enough to pay all the expenses. I want to set up these accounts here, pay on death to my grandchildren, for example, and they're older. Or this group of accounts can go pay on death, but I want to make sure there's enough money in the trust to pay trust expenses until your house is sold or your medical bills or whatever. But again, if you are still alive and you are incapable of getting to that, and it's not in trust, I can't get to it. And the bank's not going to give it to me until I show them a death certificate. But if it's in the name of the trust, I can get to it. And it goes to the same person at the end of the day anyway. As a co-trustee. Now I remember your file. Now I remember. Okay. Yeah, so if she's co-trustee, that's a different story. That's why your daughter came from LA, right? Okay, now I remember. I'm sorry.
Woohoo, look at you.
Anyway, so yeah, yours was taken care of, and as a matter of fact, I recall we discussed that. That's exactly what we're talking about now. Now I remember. Okay. Any other questions?
So I have one. So I worked in a bank, just like your daughter, and it was a wealth of information into the financial world of what's going on. But I do believe that there's different verbiage that we used to use in the 80s and 90s when I worked in a bank. So as a suggestion to all of you, you might want to get in your mind what it is that you want as the vesting on that account before you go forward with, Lila Basham Castellos as trustee for Charles and Craig Basham, who are my two sons, versus Lila Faye Basham Castellos, POD, Charles and Craig.
So that creates problems.
It does. It does. But I'm making a blanket statement about vesting on accounts.
Well, I recommend the vesting on the accounts are exactly the name of the trust. So if you have the Bubby and Zadie, and again, it would be Bubby and Zadie Trust. Now, it could be revocable trust. It could say family trust. It could say whatever. Mine says Intervivos Trust because I thought I was so smart, so I said Intervivos. But you could say Bubby and Zadie Trust dated June 11th. That's the title. You change that, and you go to a bank, and they're going to say, it doesn't match your trust. I had that happen. And I know that some banks, again, my daughter works in a bank, and she calls me, and there's a very, very famous bank in town, or known bank in town, I won't mention it, and somebody there says, if the trust name doesn't have revocable or family in it, we're not going to open the account. Oh my gosh, that's crazy. And why? Well, that's just the way it is. It has to say family or revocable. No, it doesn't. It doesn't. I mean, it doesn't. It doesn't have to say revocable. It doesn't have family. Now, normally what I do, and most attorneys will put the Bubby and Zadie Family Trust. We just do that. But I don't have to. I've had some just say some guy was telling me I wanted as short as possible. So I just said, Bubby & 80 Trust. And then you always put the date. But I've had some that, that will say revocable living trust, revocable living family trust. But this one bank says, somebody that says in the legal department who is a not lawyer, not even a paralegal, says, nope, it's got to say family or revocable. And I had a client come to me and said, I've been dealing with this bank for years and they're giving me this problem. I said, you go to the manager of that bank and tell them you don't not have to have family in it, and if they don't open the account, pull your business and go somewhere else. And they opened the account for her. And so, but we get, I know from what Molly tells me is some of the things that somebody in the bank will say, no, you can't do something. Not true. And every bank is different. Every bank is different. And some of them don't read. Let me give you another story about a probate. I had a probate, it's the one and only one I've had in Orange County for a while, and I will never do another one. And what had happened was during COVID. And the only asset of this estate was a bank account with $220,000 in it. And we opened up this account, and the client opened it at Chase Bank. Then COVID hit, and she moved to Arkansas. And then when we got ready to distribute, she said, I can't come back to California. My husband is ill, I can't leave. There's no Chase Bank in she said there's one in Oklahoma City or something, I don't remember, hundreds of miles away. And she said, I can't get to a bank. It was during COVID. How do I get this money? So what I did was I filed a petition with the court and asked the court for a court order releasing the money to me as the attorney for the estate. And I put down there that, I've been an attorney so many years, I work for a firm that's been here for so long, and here's the reasons why. The client's in Arkansas because of COVID, she can't come, we need to get the money. I got a certified copy of a court order that says pay, actually I work for a firm called Reed & Hellier, so it's a Reed & Hellier Attorney Trust Account. I get a certified copy of this order, and I go into this Chase branch up here, and I talked to the lady, and I explained the situation, and I said, here is a certified copy to pay my firm. They said, no. Oh. What do you mean, no? The client has to sign. I said, that's the whole point of the court order. She can't sign. Well, the woman I spoke to said she passed it on to her supervisor, and whatever. It came back, no. And you couldn't see how red my face got, but I have a court order says pay me. Well, they're saying it only could be released if the person who opened the account signed it for us. I said, what happens if that person died? Then who would sign for it? Well, we would need a court order. So I'm explaining to the lady, and she was very nice. It wasn't her fault. I said, look, I know this isn't your decision, but you need to pass this on to someone who knows what they're doing, because you are ignoring a court order. Are you really want to do that? She says, let me call you back. Calls me back a few hours later and says, come on in, we'll get you the check. So I ran over there, because it was Chase Bank, the one over here. And she said to me, after I spoke to you, I called and spoke to someone in the legal department. Well, what happened is, she didn't go to the legal department. She went to her branch manager, who has this thing that said, nope, can't do it, because it's not something we usually do, can't do it. And she finally went over that person's head to legal, and legal said, of course, it's a court order. But that's how stupid they are, okay? And every bank is different. I'll have some bank that says, I will take a copy. I have other banks, nope, I gotta see the original. I have some banks that say, we only need to see these certain pages. Nope, I need to see the whole thing. I've had a bank say, we need to see the original wet signature. Why? It's our policy. Why? It's our policy. I once asked a bank, let me talk to you. I want the phone number of your legal department. And they gave me the middle finger and wouldn't let me talk to the legal department. So I complained to the manager about it, and the manager said, let me look into this for you. And she called me back 2 hours later and said, come on in. Okay, so it just depends on the bank, just depends on the bank.
And when you initiate a court order, it takes a long while, other than a circumstance like that. I mean, there's a court order process.
Well, it depends. What I did in my case, I did what we call an ex parte order, which is like an emergency order, and I didn't need a hearing. I had I had my client from Arkansas sign it. I had exhibits, I had attachments, and I explained to the court what was the issue, and they did approve it for me. But if you had to get a hearing, this was Orange County, it would have taken 6 months. Riverside, you usually get in 30, 60 days. It depends. If Sherry was here, Sherry could tell you more about that. But again, dealing with banks is very, very, very frustrating.
And lastly, what was I going to say? Oh, you don't. The trustee doesn't necessarily need a lawyer to finalize a trust, right? It can be done if everything is in order. The trustee can handle everything according to the
Ron,
wishes.
I'll answer this.
Pardon me? Okay.
I could fix my own computer if I know how. I could take my own appendix out if I know how.
Yeah.
The problem is in anything, and so, a lot of people don't want to spend the money. That's cool. So something that would take me 4 months takes you 8 or 9 months, or you got to come to me and I got to clean it up. You are required in a trust, I didn't talk about this, but you are required to, within so many days of the trust becoming irrevocable, providing that notice of 120 days. If you don't give that notice, the 120 days never runs, and that means you're susceptible forever. That 120 days cuts off your liability, okay? Another thing, you're required to give an accounting. And a lot of times what happens is this. You have somebody doing their trustee, their administrative trust, and I tell everybody, keep records. You are required by law to account a minimum of once a year. You have to account to the heirs, beneficiaries, what you started with, what came in, what went out, why it went out, and what's left. And if you don't do it, you're going to get sued. And I tell people, there's very little I can guarantee you in law, but I'll guarantee you this. You don't do an accounting, you 100% chance the judge is going to order you to do it. There's no excuse, okay? Recent case, parents died in 2004. Client thinks he's really smart, and he's going to administer this trust, and mom and dad were investors and had some real estate out in Woodcrest. He's going to develop it. 20 years later, he still hasn't developed it. And his sister sues him because he'd never given her an accounting in 20 years. Oh, and he's mad, and he's blaming everybody, and blaming the world. And he had to go back and dig up 20 years worth of records and provide her 20 years of accounting. Finally got done about a month ago. Took 2 years. And trying to find canceled checks, find receipts. He had to go back to his accountants. And one of the accountant firms that he used to use isn't in business anymore. It was just a hassle. But he got sued, and I told him when he walked in the door, I guarantee you the judge will order you to produce an accounting. And that's one of the few things I can guarantee you. You will get required to do an accounting. So amateurs don't do it, and they get sued. And then the accounting they don't give correctly. We will also find in some families, let's say, let's say a Hispanic family. The older brother takes steps in the shoes of dad, right? He's the El Jefe, right? And he says to his younger siblings, I'm in charge. You shut up, keep your mouth shut, or you're not getting anything. And I've had that happen many times, that I've now been hired by one of these younger siblings that have to go after his or her older brother and say, you don't make that decision. You can't cut us out because we're asking questions. Where's the accounting? You sold mom and dad's house 3 years ago. How come you haven't distributed yet? So yes, you could do it by yourself if you know how. And if your family gets along and nobody's arguing and it's all cash, I've told people, again, come in, mom and dad left bank account, I have my brother here, we're best friends, we're whatever, what do I need to do? Well, you know something? You think your brother's ever going to sue you? Hell no. Hell, give him half the money. Who's going to question it? He's the only other heir. He's not going to want an accounting. Just save some money just in case you have to file a tax return. But, like I said before, you can do it yourself if you know how. But a lot of people get in trouble. Like my client, 20 years. Had he come to see a lawyer, gone to see a lawyer 20 years ago, would have told him you got to do an accounting every year. It would have been so much easier. But, it's like anything else. You're smiling. Tim?
So when somebody sends a check to your account or the trust, do the banks require the name on the check to match exactly what's on the checking account?
Okay, I don't understand. Say it again.
So somebody sends a check to Bubby and Zadie Trust, but the bank account says Bubby and Zadie Trust dated 1998 or whatever.
Oh, you mean the date's missing?
Yeah.
Usually the bank, I think, would accept that. The reason the date is important is because people redo trusts. I've had, again, somebody comes in to see.
And it gets amended.
Well, normally what you do, you amend it or you restate it. And even if you amend and restate, the date of the trust remains the same, just like your birthday. You change your name, your birth date remains the same, right? Your social security number remains the same. So if you amend your trust or restate the trust, it's still the original date. But I've had people that created a trust, let's say happened recently, 1992. Then he came back 2015 and did a new trust, the 2015 trust. Now, if the date wasn't on there, which trust are we talking about? Because I've had that happen. Again, a bank's going to look at this. Let's say the 1992 trust has the same name as the new one, but different beneficiaries. Because the wife died and the husband remarried. How's that? Which is which? And it gets to be a problem. So you want the date. I always put the date. You might see UDT, under declaration of trust sometimes. I just write dated, but you might see UDT, under declaration of trust, and you put the date. So, but if the bank, if you had a check payable to Bubby and Zadie Trust, and I walked in with just a check to Bubby and Zadie, it's not the same. Your bank might hassle you on it. And then Bubby and Zadie both die, you have to get a new tax ID number. Can't use their socials. I don't think I answered your question.
Well, you did, but so it raises another question, though. So the bank account needs to have my individual name and the trust on there.
It's usually, are you the trustee?
Yes.
So that's the correct title is Tim, trustee of the Tim Trust. Okay?
With the date?
With the date, of course. Yes, yes.
Does it have to have a tax ID number?
Not on the name.
No, but the trust has that.
Well, yeah, and during your lifetime, it's your social security number. Okay?
Excuse me.
Okay. Upon your death, one of the things that we do immediately or initially is we get a new tax ID number, an EIN. Okay? Takes about, I do it online, takes 10, 15 minutes, and I get a new EIN. So if, let's say you had a trust and Tim is the trustee, let's say. So what I would do on Tim's behalf as trustee, I get a tax ID number for the Carol Lee Trust. And when you do it, the IRS form says who's the responsible party, Tim Beld. Then it says, what's Tim Beld's social security number? And I got to put that in there. So then it'll ask the name of the trust, the date the trust was funded, is it revocable or irrevocable? Upon your death, it's irrevocable. And it asks, are you going to have any employees? No. Do you? And I think there's a question. I think a question might be if you sell something. I don't remember now. I do so many of these. I don't remember now. And then you check the boxes, push the button, and within 2 or 3 or 4 seconds, they generate a letter that has a tax ID number on it. Then what I do is I highlight the number. It's in the upper right-hand corner, hand it to the client, and say, take this with the trust and the death certificate to the bank. And then the bank, like I said previously, will copy what they want to copy. They got the tax ID number. They copy that. They usually scan all this stuff. And then they'll get your information and open up an account. Okay? If it's done correctly and everything's in order, it should be pretty easy. But if you got a name that doesn't match, or a date that doesn't match, then you're going to have a problem explaining what it is. If you have the wrong date on the, or something when you transfer your house to your trust, you sign a deed and you transfer it by recording a deed. If it doesn't match and now you want to sell your house sometime down the line, title company says the dates are wrong. How do we know there aren't two different trusts? How do we know which one it is? And you have problems. So you have to be very careful that when I do a deed transfer in the house, I get a copy of your deed. I can get it from my office. It takes me a couple minutes. I put in your address, and I can get your deed. And when I do a deed to the trust, I make sure that the grantor on the deed matches exactly what your deed says today. And then it transfers to Carol E., trustee of the Carol E. trustee to June 11th. Okay? Very, very important because, again, we've had it come back where there's a typo, and now we've got to explain it. And it can, I don't want 5 years, 10 years from now, or whatever it is, you're selling your house or refining it or whatever it is, find out, whoop, we got a title problem. That dumb lawyer didn't fix it all those years ago. So, very, very important. I think that, in general, in today's world, people say, oh, my state isn't large enough. Well, maybe, but it protects you if you need a conservator, or instead of a conservator. It protects, it's private, doesn't have to go to probate, which I talked about before. I hate going to probate. It just takes so long. And Sherry Cruz, here's what Sherry Cruz's job is. Sherry would laugh if I said this, but Sherry's basically a legal auditor. She is a probate attorney at the courthouse. They have probate attorneys and probate examiners. All they do is they put on the little visor and they get a magnifying glass and they examine all the papers that are filed. And that's what Sherry does. She's a supervisor because she's an attorney, but they have examiners. And that's what they do. And every probate court in the state has a probate examiner or a probate attorney. So if I file a piece of paper in the probate court, somebody is looking at it very, very, very closely. And Sherry could tell you probably common mistakes that attorneys make. And then what happens is before your hearing, you can look up what we call the probate examiner notes. And you'll have a list of the defects. And what I love is RFA, recommended for approval. Okay? And we always look for RFA, and it'll say, they list it, and they'll give a little summary of what's going on, and then they'll say deficiencies. And you always want to hear none, and then it says recommendation, or it'll say RFA. Or it will say, no proof of service on Carol E., missing publication, box XYZ in the petition wasn't boxed or wasn't checked. And that's what Sherry does. Sherry, that's her job at the courthouse. And if she was here, she could tell you all the things that they see. But if it's a trust, I don't have an auditor looking over me or looking over you, checking every single box. And I'd be candid with you. I mean, Sherry makes me sound really smart when I talk to some of my clients because I call Sherry, and I don't ask her for specifics, but I ask her, what does the court want to see from me? Okay? Don't tell me how to do it because I don't want to put her in that position, but I'll say, what do you want to see? How does the court want this situation resolved? And she'll say, well, the court would want, someone's want this, this, and this. Okay, then I can handle that. I go back to the client, I think I'm so smart. But Sherry is, honestly, I'm not embarrassed to say this, but she's helped me over the years tremendously in probate questions. Trust questions are different. But probate, you got this auditor who's very sharp, and it's not only her, there's a bunch of them. Man, they catch every mistake. Or did an account, okay, I did an accounting for probate a year or two ago. I was 23 cents off. And I could not get my petition approved because I was 23 cents off. And we couldn't find the 23 cents. And so my secretary at the time went through all the bank statements again, and we found we missed 1 month's interest of 23 cents. And when we added up the monthly statements, we missed one, and it was 23 cents interest. It took probably 3 or 4 hours just to figure out what happened to 23 cents. But they would. I called Sherry and I said, "Can I get it through if I'm 23 cents off?" She said, "Probably not." So we had to fix it. But anyway, any other questions? Okay, well, nobody online? Okay.
It was really good, and
Okay, I guess we're done.
What happened?